Welcome. Today we're diving into a topic that can honestly completely change the trajectory of your life or business. We're talking about partnership disputes. Because let's face it, whether it's a business partnership that's suddenly hit a brick wall or a marriage that's coming to an end, disagreements are just an inevitable part of life. But here's the absolute crucial point. How we handle those disagreements doesn't have to be some destructive, scorched earth battle, right? Let's look at the data behind a highly structured, way less combative way out. We're going to map out the path to a peaceful resolution, focusing entirely on the facts, the data, and the real-world application of professional mediation. So how are you stuck? When you're in the thick of a serious dispute, whether you're untangling years of a personal relationship or trying to separate, really complex business assets, it's incredibly common to feel completely deadlocked. You might be feeling totally overwhelmed by the emotional weight of the whole conflict. It's heavy, it's draining, and honestly, it often feels like you're trapped in a locked room with literally no exits. But listen, you are not out of options. To help you navigate out of that locked room, here's our roadmap for today. First, we'll cover the stress of disputes. Second, understanding the mediation process. Third, we'll weigh mediation versus litigation. Fourth, we'll look at when mediation actually falls short. And finally, finding your ideal mediator. All right, Section 1, the stress of disputes and how to avoid the court fight. When a partnership breaks down, let's take Johnson County as an example today. People tend to default to a pretty terrifying assumption. They just assume a brutal, expensive, drawn-out court fight is the only way out. Just the thought of lawyers, judges, and public courtrooms, yeah, that's enough to make anyone lose sleep. But you can avoid court, you can break the deadlock, and you absolutely can stay in control. These aren't just motivational buzzwords, right? They're the tangible benefits of stepping away from that litigation battlefield. You actually have the power to choose a path that lets you keep personal control over the outcome, rather than handing your entire fate over to a total stranger in a black robe. Okay, let's dive into this next part. Section 2, Understanding the Mediation Process, a Neutral Path Forward.
So, if we're taking court off the table entirely, what exactly are we replacing it with? Well, a mediator is a neutral third party who guides partners to reach a mutual agreement, rather than making choices for them. I really want to highlight that word right there, guides. A mediator is not a judge. They don't sit at the head of some big mahogany table, bang a gavel, and dictate who gets what. Instead, they provide a safe, private, and highly structured environment. Their whole job is just to facilitate a productive conversation, keeping it focused on solutions rather than pointing fingers and placing blame, so that you and your partner can forge your own resolution. In this scenario, you are the architects of your own settlement agreement.
And the real power of this process lies in its incredible flexibility. It works for everything from the division of assets and property to incredibly sensitive topics like money issues, spousal support, and child custody. But keep in mind, it's not just for family law. Mediation is highly effective for complex business-related problems too. Think about, say, a multi-million-dollar commercial real estate deal gone sour, or a really bitter falling out between tech startup founders. Because the process is completely tailored to the specific people involved, it can handle almost any kind of conflict where two parties need to untangle their shared interests and just move forward cleanly. Moving right along. Section 3, Mediation versus Litigation, choosing the best path. Let's actually put these two paths head-to-head. On one side, mediation offers a private record. That means your personal or business laundry isn't aired out for the whole world to see. It offers high personal control, meaning you decide the outcome. And it offers a much faster resolution, often wrapping up in just a few short weeks or months. Now, on the exact opposite side of the spectrum, we have litigation. Court proceedings create a public record. A judge, literally a total stranger, dictates the final outcome, completely stripping you of your control. And, perhaps worst of all, litigation can drag on for years, keeping you trapped in this perpetual state of conflict and stress. It is literally a night and day comparison. Now, what's really interesting about this slide is, well, let's just pause for a second and let the financial reality fully sink in. The average total cost of mediation ranges from $5,000 to $15,000. Compare that to litigation, which starts around $15,000 and can easily skyrocket past $50,000. Why the massive gap? Well, because with litigation, you're bleeding money through attorney fees, court fees, expensive consultant fees, and trial costs. But with mediation, you have high control over your costs because you're primarily just paying for the mediator's time and some basic filing fees. Honestly, the financial savings alone make this an alternative you simply cannot afford to ignore.
All right, Section 4, when mediation falls short, knowing the limits.
Now, to be completely clear, mediation is not some magic bullet. There are strict exceptions. The whole thing relies entirely on good faith and safety. Therefore, it's generally not suitable in cases where there is domestic violence or abuse, because, well, a fair negotiation simply cannot happen if one person can't participate safely. It also fails if one partner flat out refuses to compromise or even communicate at all. Furthermore, if you suspect there are hidden assets or blatant dishonesty going on, the discovery powers of a formal court might actually be necessary. And finally, if your dispute involves a highly complex issue or a formal legal precedent needs to be set for the future, mediation just won't achieve that. In these specific, highly complex situations, the strict rules and structure of the court system are absolutely necessary to ensure fairness and safety. Finally, Section 5. Finding your ideal mediator. Selecting the right pro. Assuming your situation doesn't fall into one of those exceptions, how do you get started? Well, you absolutely cannot just pick a name out of a hat. You want someone with formal mediation training and certification. For example, look for elite, state-level credentials like being Kansas Supreme Court approved. That's the exact caliber of official high-level approval you should be looking for in your own jurisdiction. You also need to ensure their specific experience matches your specific dispute. A great family law mediator might not be the best choice for a complex commercial real estate dispute, right? So look for positive client testimonials and active membership in professional dispute resolution organizations. These are your markers of true quality. So here's your action plan for that all-important initial consultation. Step 1. Discuss fees up front. Ask if they charge an hourly rate or a flat fee so there are zero financial surprises later on. Step 2. Evaluate their experience. Keep in mind, a less experienced mediator might charge a lower hourly rate, but a seasoned pro might solve the problem in half the time, actually saving you money in the long run. Step 3. Check those client reviews to verify their track record. And finally, Step 4. Trust your gut feeling. You're going to be discussing some highly sensitive, really stressful topics with this person. If their communication style doesn't make you feel comfortable and heard right off the bat during the consultation, keep looking. So here's the big question to leave you with. Are you ready to preserve your relationships and take the next step toward a peaceful resolution? We've seen the data, we've walked through the process, and we've compared the heavy financial and emotional costs. You really do not have to accept the default combative path of litigation. You have the power right now to step away from the battlefield and seek a collaborative, structured solution. The choice is entirely yours. Thanks so much for joining me today.